There we go. Good morning, everyone. My name is Diana Shulak. I'm Director of Operations at Family Focus Resource Center. I'm at the Cal State University Northridge office, but we also have offices located in the lobbies of the North LA County Regional Center in Chatsworth, Santa Clarita Valley, and Antelope Valley. We are a resource center, a nonprofit resource center who help families that have children and young adults with disabilities. And one of the things we do is host these wonderful workshops for you to become more aware of different services available to you and your family. And today we have the final part of our generic series, a generic services series. Today it's going to be IHSS Appeals. Hosted by Disability Rights California. I'm going to turn it over now to Raymond. We will have questions at the end, so please reserve your questions till our question and answer period at the end. We will pause the recording at that time because we don't like to record people's questions. But if you do want to put your question in the chat so you don't forget about it later, you are able to do so, but we will be covering those questions that are in the chat at the end as well. So I'm going to go ahead and turn it over to Raymond. Thank you, everybody, for being here. Thank you, Disability Rights. Thank you, Raymond.
Good morning, and thank you for having us again, and thank you for all the attendees who are here this morning. My name is Raymond. I am an advocate with Disability Rights California. With me today is Carla. She will be monitoring the chat for questions, and of course, our presenter today is one of our senior attorneys, Maria Ariate. So just a quick overview of who we are, what we do, in case you don't know. Disability Rights California, or DRC. We are a statewide nonprofit, and we provide free legal services to people with disabilities with any disability-related issues. We have offices statewide, and we have advocates and attorneys that can handle different subject matters, from access or discrimination with housing, with transportation, with education, which includes special ed and higher ed. We can also help with employment reasonable accommodation issues, public health benefits such as Medi-Cal, in-home supportive services, Social Security overpayment issue that relates to work. And within our agency, we also have different programs, examples of which is our Office of Client Rights Advocacy, or OCRA. They specialize in helping clients of the regional center, and our Client Assistance Program, or CAP. They specialize in helping clients of the Department of Rehabilitation. So as our host said, we'll have question and answer at the end. Everything you see today, PowerPoint, along with anything, websites or resources that might be shared in the chat, you'll get it after the presentation. If you'd like to speak to one of our advocates one-on-one about your specific issue, please give us a call. Our number is already in the chat. It's 800-776-5746, and our phones are open Mondays, Tuesdays, Thursdays, and Fridays from 9 a.m. to 3 p.m. So without further ado, I'll pass it over to Maria. Thank you again.
Oh, I had to unmute myself. Hi, everyone. So we are going to talk about what happens after you get that notice of action and you're not happy with it. And so we are going to use the case example of a little boy named Emilio. And so we'll follow the what do you do after the notice of action along the way with his case example. But we are going to talk a little bit about notices of actions, timely notice, adequate notice, and what all that means. And then we're going to talk about how to prepare for a hearing, what happens during the hearing, and things after the hearing. So Emilio is a 12-year-old boy who's been receiving IHSS, including protective supervision, for at least 5 years. And he had a reassessment last in December of 2024. And mom received a notice of action dated January 5th of this year, saying that they were going to take away his protective supervision because of two reasons: that he's self-directing and that he doesn't need 24/7 supervision. Obviously, mom wasn't quite sure what all that meant, but she was not happy, and she went ahead and she read the notice of action, because in the back of the notice of action, it tells you how to appeal, the different ways to appeal. So she called the State Fair Hearings Office and appealed. the notice of action. So what is a notice of action? It's a document that explains when you apply for any California public benefit, it'll tell you whether you became eligible or not. If not, then why not? If you were applying for services, say you're on a program and you want more services, or they want to terminate services or reduce services, they've got to give you a notice of action. And the notice has to be adequate. It has to have what is being contemplated, why they're doing what they're doing, what regulations, statutes, etc., support the county's action. Hearing rights, very important. With an IHSS notice of action, you have 90 days from the date of the notice to appeal. But if you want aid paid pending, you have to appeal before the effective date of the notice. And what is aid paid pending? It means that in Emilio's case, let's say that the notice of action was dated January 5th, but within the notice of action, it says starting February 5th, you're going to lose your protective supervision. So as long as mom appeals before the effective date of the notice, which is February 5th, not January 5th, but February 5th is the day that he will lose his protective supervision. And when she called state fair hearing, she appealed and she asked for aid paid pending. So what does that mean? Come February 5th, nothing's going to happen to the protective supervision until there's a hearing decision or it settles along the way. And if the hearing decision is favorable, then Emilio will continue with his protective supervision. Now, what happens when people ask for aid paid pending is that typically they'll receive another notice reinstating here the protective supervision. And don't be confused. It doesn't mean that suddenly you've won your case and you don't have to go to hearing. It's just the county reinstating the service because you asked for aid paid pending. But the hearing's still going forward. But you can get confused with these notices. So if you appeal, you ask for aid paid pending, and you get another notice undoing what they wanted to do. It's just that it's because you asked for aid paid pending. And so reading the entire notice is really important. Many times I've spoken to people who have received notices and I ask, well, did you appeal? And they say, well, I don't know how. And I know they didn't read the notice. So very important. The notice will also tell you if the county needs any other information. So you should, if the county does indicate that in the notice, then please, provide that information to the county. Now, this is what a typical notice looks like for a person who's already receiving IHSS. So the date of the notice, for example, on the right-hand side, it would be for Emilio, January 5th, 2025. But as you see down here in the first rectangle, as of, and let's say it says February 5th, the services you get will be reduced. Like you'll get, in Emilio's case, it'll be, they're going to take away his protective supervision. But as long as mom appeals before the effective date, which is February 5th, and asks for aid paid pending, nothing will happen come February 5th. That's what aid paid pending is about. Now, if you've indicated to the county that you need notices in your language, and your language happens to be a threshold language in the county, meaning that it's spoken by at least 5% of the population, then the county has to give you your notice in your language. If your language is not a threshold language, then the county should provide interpretive services. You need to let the county know that you want it in your language, and hopefully it's a threshold language, so you get that notice in the threshold language. There's also another concept called timely notice, and timely notice means that the notice that is sent to you has to be sent at least 10 days before the effective date of the notice. So in the case of Emilio, the effective date is February 5th. So it needs to be mailed to Emilio at least 10 days before the effective date, which is February 5th. If you didn't get timely notice, that could be part of your appeal, but the judge is going to say, honestly, he's going to say, most likely he or she's going to say, well, you're here, right? So, do you want to, what do you want? You know, but some people have received notices after the effective date of the notice came and went. And that would be a reason to be able to call the state fair hearings, appeal, and ask for aid paid pending, because you were never even given that opportunity. So really important. Read your notices. How to request a hearing. You can request by phone. I always would call in my request for hearings, because 9 times out of 10, they would give me a case number, and that would be my proof that I appealed on time. When I didn't get a case number, I would call the next day and they would give it to me. But you could mail it in. There are different ways to appeal to state fair hearings. State fair hearings is a division within the California Department of Social Services. California Department of Social Services administers the IHSS program in the state of California. If you're not quite sure whether you want to appeal or not, just appeal. You can always withdraw your appeal. It's very easy. Yeah, all you have to do is call state fair hearings and say, I no longer want to have, I don't no longer want to appeal. Fine. So this is an all county letter. So California Department of Social Services sends all county letters, all county information notices, et cetera, to counties to update them on things, to direct them about certain things. So this is about, how the process for withdrawing a hearing or a rehearing request. I'll talk about rehearings later, and conditional withdrawals. And so there's the all county letter there, and a summary guide. It's very easy to withdraw. It's very hard to appeal late, because you're going to have good cause for appealing late. Now, what's a conditional withdrawal? Emilio's mom is going to get a letter from the person who's going to be representing the county at the hearing. That's called the appeal specialist. And it's an opportunity, or it should be an opportunity, for the claimant, in this case, Emilio, through his mom, he's the one who asked for the hearing, and the county to try to resolve the matter. And actually, there's an all county letter, I think it's in the next slide, that talks about the appeal specialist's responsibilities, which is really to try to resolve the matter. And it does happen from time to time that people don't have to go to a hearing because they've resolved it. Now, in Emilio's case, the appeal specialist may say, you know what, you're right. We should never have taken away the protective supervision. Let's enter into conditional withdrawal, where we withdraw the notice, and Emilio, continues with his protective supervision, and everything is hunky-dory. The more likely scenario is that the appeal specialist is going to say to mom, hey, let's enter into conditional withdrawal because we want to reevaluate Emilio again for protective supervision. Now, mom has choices. She can say, sure. Or she can say, no, you already had your bite at the apple, and so I want to go to hearing. So she can say no to that. Sometimes people say yes to that because they hope that with this reassessment, the county will find that they continue to need the services. But it's possible that if mom says yes and they have to reassess within 30 days, a mom gets a new notice saying, we're going to take away the protective supervision again. So just because you agree to a conditional withdrawal doesn't mean that, things are going to change, that this county is going to change its opinion. In fact, with the reassessment, the they're just going to have more information to prove their case, right? Because now they're going to get more information. They should have done a better assessment when they came out and reassessed him. But this is an opportunity for the county to kind of gather more evidence. Also, you have to weigh the risk and benefits, of what you want to do here when they offer a conditional withdrawal. Make sure you understand what you're agreeing to. If you're not getting aid paid pending, make sure that the conditional withdrawal is retroactive to the date that you lost the services. Because otherwise you may not get it. There is something called the Appeals Case Management System. So I'm going to go ahead and open this up. I'll show you. So mom can decide that she wants to manage the case file electronically. And so what she would do is she would create an account. She would use a username and password to be able to get into the file folder for this case. So that anything the county submits will go electronically into the file. Any communications from anyone at State Fair Hearings would go through the file electronically. And when it comes time to, if she's not going to have an in-person hearing, she can submit all of her evidence electronically through the system. Now, it's only if you're comfortable using this, using this technology, because if you're not, then you don't have to sign up for the appeals case management system. You can just do it the old-fashioned way, which is, I'll talk about it, but well, for example, if mom is not going to have an in-person hearing, she's going to have to figure out how to get her evidence and perhaps a position statement to State Fair Hearings before the hearing. She may have to call State Fair Hearings and say, how can I get this to you? They may accept facts. She might, if she lives close enough to State Fair Hearings to go and leave it there. So, it's just trying to figure out how that's going to happen when you don't do it electronically. But people do it all the time. So this is an option for people who might want to manage their file with State Fair Hearings electronically. So let's go back to, and here is the link to that appeals case management system. When you're appealing, things to consider: if you need an interpreter, you can ask for one at that time. Let's say that mom didn't ask for an interpreter because she thought she could, understand enough to, do the hearing in English. But then at the hearing, she realizes that she's not really understanding a lot of what is being said. She can stop the hearing and say to the judge, Your Honor, I need an interpreter. I'm not understanding. I thought I would be able to. And the judge can call an interpreter on the phone and get an interpreter on. Now, I've been at hearings where we've had to change interpreters 2 to 3 times because they're so bad. I'm not saying they're all bad, but, I've had enough experience to say, the chance of getting a good interpreter is iffy. And so it's up to you when, you should bring someone to the hearing who knows both languages, so that if anything, if the interpreter is not doing his or her job correctly, that needs to be brought up. Because if it doesn't, what the interpreter says to the judge in English is the evidence, although it was that wrongly interpreted. So, and the judge is going to make his or her decision based on the evidence, right? So if the evidence is incorrect, then it's possible that the decision could be incorrect because of that. If you need a reasonable accommodation, or the claimant needs a reasonable accommodation, it should be asked for. So let's say, for example, mom wants to take Emilio, but mom knows that Emilio can't sit still for more than 15 minutes. As an accommodation, she may ask that the judge, assess him within the first 15 minutes, or at least give him a break. It's not that the judge is going to ask him questions, but sometimes they like to just see the claimant. And I've had children at hearings. Um, and I know in one, the child, we were arguing for protective supervision. The child, for the first 2 hours, just sat there without doing anything, no behaviors, nothing. Her mother was there, and the person who cares for her, the provider, was there. And the judge at one point stopped the hearing and asked, "Well, yeah, I'm not noticing any behaviors here." And the mom said, "Well, that's because we're here. And both of us, the caregiver and I'm here." And as soon as the judge questioned that, the claimant started picking at her skin. So she started to have behaviors, but it's not that behaviors have to happen every minute of the day, but you do run that risk when you take people that they may not be exhibiting the behaviors that you're arguing the person has, right? But you can bring in testimony, you can bring in documents, you can bring in videos to show all of that. A subpoena, if you want to have documents brought to the hearing or people brought to the hearing, you can ask that are not going to be at the hearing, or you suspect are not going to be at the hearing, and you need them to be there because you want to question them or question the documents or use the documents in your favor. Then you need to ask State Fair Hearings to allow you to issue a subpoena for the person and or document. Let's say that Emilio's hearing is next week, but mom's not ready because the doctor hasn't issued a report, and it's going to take longer than a week to get that report. And so mom can call State Fair Hearings and ask that the hearing be continued. The first time, they're going to ask why. More likely than not, they'll grant the continuance. But every time mom wants to continue after that point, she's going to have a really good reason. Now, by law, you're entitled to an in-person hearing, but what's happening now is that the letter you received about the hearing is going to say most likely that it's going to be a phone hearing. You can have the phone hearing if you want, but if you want an in-person hearing, you've got to call State Fair Hearings and say, "No, I want an in-person hearing." And they'll say to you, "Well, we're going to have to change the date yet because what we had scheduled was for a phone hearing." Fine. Sometimes you can ask for a video here, Zoom hearing or a home hearing. If the claimant can't get out of the home and the claimant wants to participate in the hearing. Expedited hearing, that's kind of cutting into the front of the line. There are a lot of people waiting for hearings, so you're going to have a really good reason for wanting to have an expedited hearing, right? Meaning you can't wait until a month or two before you get your hearing date. There's some kind of urgency that requires that you have that hearing so you can get those benefits sooner rather than later. Typically, hearings are scheduled for about 2 hours. If your hearing extends beyond that, then you're going to get a new date for a continuation. I've been at hearings for a case that have continued 4 times because there was a lot of evidence to go through. And so it all depends on your case. So mom appealed. State Fair Hearings is going to send her a letter saying, we acknowledge your appeal, and soon you'll hear from the appeal specialist. Then mom will get a letter from the appeal specialist saying, "Hey, I'm going to represent the county. I really would like to talk to you about the case." Talk to them. And here is the all county letter on their responsibilities to try to resolve the case too and not have to go to hearing. The next letter that mom receives will be the letter with the date, time, and place for the hearing. Now, State Fair Hearings have procedures that you need to follow. And those procedures are contained within the Manual of Policy and Procedures 20-000. And I'm going to open that up in a moment. Also, there's something called the Administrative Law Judge Book, Bench Book. And there's a lot of really good information. These are kind of instructions to judges on what they need to do, especially during the hearings, when things come up or afterwards or before. So let's go to the MPPs first. So procedurally, it starts off with definitions, determine the time to appeal, your right to a state fair hearing, how to request a state fair hearing, the time limit to request a hearing. And then we've got setting the hearing, about group hearings, hearing general rules and procedures, about evidence, subpoenas. If you get a witness to be subpoenaed, they get reimbursed fees and mileage, postponing and continuing a case, dismissing a case. How do you disqualify a judge? You're not going to know who the judge is until the date of the hearing, but maybe you've had that judge before and you feel that the judge is very biased. Well, you're going to have to look this up and see when you can disqualify a judge. Under what circumstances. Communication after the hearing with the judge. You cannot communicate solely to the judge. You always have to include the county. There's no what is called ex parte hearings. So if I'm representing a claimant at a hearing, I can't reach out to the judge after the hearing on my own without including the county. And neither can the county do the same thing. And the judge will tell you that. Action by the director, that's called an alternated decision, and I'll talk about that. How you can get the recording of your hearing, because the hearings are recorded. You might want it for a rehearing, or you might want it for an appeal about rehearing. So anyway, lots there. And then we have the bench book. Let me just I need to open that. Okay, so let's go to the bench book. And so how does, for example, abandonment? When should a judge consider a case abandoned? The claimant doesn't arrive at the hearing. Well, there's a process for considering it abandoned. And if you didn't arrive at the hearing, you might want to look this up to see what you need to do in order to get it back on track. You can always call state fair hearings about aid paid pending. Sometimes judges will issue aid paid pending at the hearing. About continuances, disruptive participants. How does a judge handle a disruptive participant? Ex parte discussions, not allowed. The remarks that the judge will make at the beginning of the hearing, the forms that the judge can use. Identifying the issues, really important to identify the issues for the hearing. The use of interpreters, oaths, postponements, rehearings, etc., withdrawals. So there's a lot of good information there. Okay, so there are the links to both of those documents. So now let's talk about preparing for the hearing. How is mom going to prepare for this hearing? So she has to identify the issue, be very clear as to what the issue is at the hearing. The issue at the hearing is that the county wants to take away Emilio's protective supervision. That's the issue. If she brings up all the other stuff she's angry at the county about, the judge is going to say, whoa, not here. These are not the issues before me. The only issue is you appealed a notice of action dated January 5th, and that's because the county wants to take away the protective supervision. The judge is not going to consider anything else unless both you and the county decide that they want to consider another issue. And I can tell you that the county is going to be very focused on the issue for the hearing. Because and I mean, if the county were to say, well, I want to focus on this other issue and I'm representing someone at the hearing, I say, wait a minute, I didn't even prepare for that. No, I don't agree to that. So very clear here what the issue is. You're going to find it in the notice of action. In your conversations, obviously, with the appeals specialist, you're going to know more about their arguments, why, what evidence they're using to say that Emilio is self-directing. And that he doesn't need 24/7 supervision. Of course, the appeal specialist is going to know more about your arguments too, but you're getting information, they're getting information, and maybe there can be some resolution. The claimants have the right to review their file, and that's MPP 22051.1. So mom can call the appeal specialist and say, I want to review the file, because in the file, the reassessment that the social worker did will be there, everything that was written on the day of the assessment. And she might find useful information or information that she gave the county social worker that's wrong. And she could bring that up at the hearing. Or she told mom about some of Emilio's new behaviors, and it's not in the file. It's not even in the reassessment report. And she could bring it up at the hearing when she cross-examines the social worker and says, well, I told you this, this, and this, and none of this is in your in this reassessment report. Why not? The county's position statement. So the county has to give you their position statement and all the evidence that they're going to present at the hearing 2 days before the hearing, and also the witnesses they're going to bring. So that's only 2 days before the hearing. 2 days before the hearing, you should be pretty much set to go. But looking at reviewing the position statement can also help you in maybe identifying things you didn't consider before. And so those are all good ways of honing in. Here it's very clear, right? It's protective supervision. There's an all-county letter about position statements. Mom can decide that she wants the appeal specialist to email her the position statement and evidence. Or maybe mom will go to the office where the appeal specialist is and pick up all of that information. However, she needs to figure it out with the appeal specialist as to how she's going to get this information. And so this all-county letter also talks more about position statements from the county. Okay, so we've identified the issue. Now she has to understand the law on protective supervision. What do the regulations say about protective supervision? Well, there are the MPP starting at 30-700. These are the regulations for the IHSS program. And within these regulations are regulations about protective supervision. So she's going to look at that. There's also an all-county letter 15-25. And Raymond, I don't see the link to this letter. We should include it. If you could just remind Lonnie when she sends out the information. So there's an all-county letter about protective supervision. It's focused on minors, but really it applies to adults. The only difference is that there are 3 criteria that adults need to meet and 4 criteria that the children need to meet. But I'll talk about that in a moment. Children are considered anyone below the age of 18. And we also have a publication about the IHSS program also would contain within that. It talks about protective supervision, and we have a separate publication on protective supervision. So mom has looked at all of this, and now she understands why in the notice it says that he doesn't need protective supervision because he's self-directing and he doesn't require 24/7 supervision. This is the criteria for protective supervision. The first 3 apply to adults and children. The last one is for children only. So adults have to prove 3, children have to prove 4. So you have to show that you have a mental disability, whether it be developmental, psychiatric, traumatic brain injury, dementia, Alzheimer's, whatever it is, and that because of that mental disability, you are non-self-directing. In other words, that the behavior you're going to do or are about to do, you don't understand that in doing or about to do those behaviors will cause you injury. So, for example, someone who opens up the hot water tap and puts his or her hand into the water, not knowing that hot water will do that because the person doesn't understand that hot water will burn you. That just doesn't understand it. Or someone who walks into the street without looking both ways because of their mental disability, they don't understand that that could be dangerous. The second criterion is that the person has to be likely to engage in potentially dangerous activities. If the person cannot physically engage in dangerous activities, then you don't meet the criteria. You have to need 24/7 supervision, although the program will not provide 24/7 supervision. It will not pay for those amount of hours. You still you have to have the need to be supervised 24 hours a day, 7 days a week to prevent you from self-injury because of your mental disability, because you're non-self-directing. And the last one that applies also only to kids, so kids 4, adults 3, is that you have to show that the child of a particular age needs more supervision than a child of the same age who is not disabled. So, okay, so now the county is using 2 of the 4 criteria to say that Emilio does not need protective supervision anymore. So there's a decision registry, and the link is here. So if you want to see what kinds of decisions have been issued in the IHSS program, you can go here. It's a good way of understanding the law and how the judges apply the laws to the facts to the law. Not all decisions, I have to say, are correct, correctly decided. Sometimes you have to appeal and win at the appeal level. But in any event, it's there. So the burden of proof is something that you need to know about when you're doing these hearings. You have to show by preponderance of the evidence, for example, that Emilio needs the protective supervision. Now, how does it work? Because the county has been giving protective supervision to Emilio for a number of years, if the county is going to take away the protective supervision, the county has the burden of going forward and showing what changed. Why, after all these years of receiving protective supervision, now you say he's self-directing, now you say he doesn't need 24/7 supervision. And it's possible that the county may have evidence for that, right? But they have to show. So at the hearing, the judge is going to go to the county and say, well, tell me what has changed between the last time you found Emilio eligible for protective supervision and now. And the county's appeal specialist will talk about that. So once the county does that, then Emilio's mom is going to have to refute the evidence, the county's evidence, right? That he continues to be non-self-directing, that he continues to need 24/7 supervision. There's also the weight of the evidence. The weight of the evidence is the persuasiveness or believability of the evidence presented. So when the judge is looking at all the evidence it's going to look at all the evidence that what each side provides and weigh the evidence, which is more reliable based on the preponderance of the evidence. Okay, how credible is the evidence that was submitted? And so the judge is going to weigh the evidence and decide based on the weight of the evidence who should win. So, for example, in a case where you have a general practitioner discussing protective supervision and why, let's say the county brought a doctor who's just a GP to say that Emilio is not non-self-directing. And mom brings in Emilio's psychologist who talks about and medical doctors who talk about why Emilio is non-self-directing. Well, these psychologists and Emilio's treating doctors are going to have that the judge should give more weight to those doctors versus a general practitioner who really is not specialized, not even in autism, perhaps, or not even in the things necessary to find that someone is not self-directing. So, there's that kind of weight that goes on. So who you bring in to testify can be important based on the weight of the evidence that's going to be given. Either the judge is going to be giving very little weight to that witness or a lot of weight to the witness, just depends. So now we know the issue. Mom knows the law on protective supervision. Now she has to gather her evidence, right? She has to show that Emilio continues to be non-self-directing. She's going to have to also refute the evidence that the county is bringing in, right? So she's going to have to deal with that. And she's got to show that he still needs supervision 24/7. How is she going to do that? Well, maybe through the IEPs, the IPPs. But she's got to look through them to make sure that all the information, all the facts are consistent. Like if the IEP says something and the IPP says something else about the same issue, who is the judge to believe, or the social worker for that matter? Doctor letters, specialist letters, records could be helpful for this. The SOC 821 is that form that the county asks to be filled out, where a doctor talks about memory, orientation, and judgment. That form is not conclusive for protective supervision. It's just a piece of evidence that's considered with other evidence to decide whether or not the person requires protective supervision. Remember, there's the criteria that needs to be met. Emilio has an ABA provider, and maybe mom will get the records or maybe ask the provider for a letter that identifies the disability, why he's non-self-directing, give examples of behaviors. I mean, the examples or behaviors are key to this, it's so forth. Witnesses, you can bring in witnesses to testify by phone, in person, if you're going to have an in-person hearing. You can create what is called a declaration. A declaration is essentially the witness's testimony, signed, dated under penalty of perjury. I use declarations all the time when I was doing casework. It just makes things go faster. So witnesses will be important to the behaviors, especially, right? To talk, behaviors will indicate non-self-directedness. Behaviors can also indicate the need for 24/7 supervision. What happened at the home evaluation? We always say, try to have someone present who can write down when the social worker came to the house, what the social worker asked, what the conversation was between everyone, and how much time was spent reviewing and having the person sign forms rather than doing an assessment or reassessment. That could be important too in the hearing. Hazard logs. If mom hasn't created a hazard log, she may want to create one for the hearing where every day she writes down those behaviors. Now, Emilio doesn't have to be injured all the time, but he has to be either doing the behavior or about to be doing the behavior. And so what was date, time, what happened? Was he injured, not injured? Just like that. And it really is, it could be very helpful. If the person is a regional center client, there's a document called the CEDAR, and it provides information on memory, judgment, confusion, disorientation. If it's helpful, mom may want to include that as part of her evidence. Videos of behaviors, photographs of injuries, perhaps. will also be important. Other things, perhaps there was an incident report or a police report that was generated as a result of a behavior. That could also be important. So the other thing that mom is going to want to do is prepare. Does she want to prepare her own position statement? She doesn't have to, but it's good for her because it makes her think, right? I mean, and the judge will have it. The judge is not going to make the decision at the hearing. The judge has other cases to decide before your case. And so by the time the judge gets to your case, memories may not be as vivid as they were on the day of the hearing. So the position statement would be, that it could be very simple, like, why she's appealing, she's disagreeing with the facts, and so it could be like, well, I disagree that that Emilio is self-directing, and this is the evidence I'm going to present. She can even testify as a witness too. And I don't agree that he doesn't need, or that Emilio continues to need 24/7 supervision. And she'll talk about the evidence she's going to present about that. And then, what does she want? She wants, he's been getting aid paid pending. So she wants the judge to find that Emilio continues to need protective supervision, that he continues to be non-self-directing, that he continues to need 24/7 supervision. So remember earlier, if she's gonna have an in-person hearing, she can give all of this at the hearing on the day of the hearing. If not, she has to figure out how to get all of this information, her evidence, her position statement, if she's going to have one, to the State Fair Hearing Office. The other thing she's going to have to think about and maybe prepare for is questions. If she wants to cross-examine the social worker, if she has witnesses she wants to do direct examination on, other people, she's going to have to start preparing some questions. At the hearing, it's nothing like this. This is like in superior or federal court. You go into a room. Typically, it's a small room. There's a table. The judge is seated at the head of the table, and each side sits on opposite sides. Who's going to be at the hearing? The judge, the appeal specialist, perhaps the social worker, perhaps a supervisor, perhaps some professional who's going to testify, witnesses, you, the claimant, maybe you have an authorized rep. If you're going to bring someone to the hearing to be your authorized rep, you can bring that person at the time of the hearing, and there's a form that needs to be filled out. Your witnesses, their witnesses, interpreters, etc. Could be lots of people. At the hearing, the record. So sometimes you'll hear the word the record. What does it mean? The record is all of the evidence that was presented at the hearing. And evidence is made up of two types of evidence. One is your testimony, your oral testimony, and the documents that were entered into evidence. What does it mean, entered into evidence? Meaning that the judge allowed it to be used at the hearing. When you are in the hearing, and you suddenly realize that you should have brought a document that would have been very helpful, you could say to the judge, Your Honor, I'd like to leave the record open so that I could submit this document to you. Because otherwise, at the end of the hearing, the record closes and no one else can submit any other evidence. But if the judge leaves the record open, and the judge agrees, the judge will say, okay, Maria, you have 1 week to give that to me, and then the county will have 1 week to respond to that evidence in writing, right? So that's leaving the record open. Why is the record important? Because if you appeal to the Superior Court, because that would be your next level of appeal, the Superior Court judge is going to base his or her decision on the record. There's no testimony at the Superior Court level. Rarely will that be granted. Mainly, it's on the record that things will be decided on your appeal to the Superior Court. Sequence of events. So the judge is going to swear in the witnesses, give some opening remarks about how the hearing is going to proceed. Then the judge is going to review the evidence that the parties have submitted and say, does anyone object to what's been submitted? And if someone objects, then they're going to have a discussion about the evidence, and then the judge will decide at that moment whether to allow that evidence to be used at the hearing. Once that gets through, then the judge is going to turn to the county and say, okay, tell me what this is about. Judge and the appeal specialist will. And if the appeal specialist has witnesses, the appeal specialist will question those witnesses. Emilio's mom, or if mom has an authorized rep, will have the opportunity to cross-examine those witnesses, right? So the appeal specialist does direct examination of their witnesses. The other party cross-examines those witnesses. Once that happens, the judge will turn to Emilio's mom and say, okay, tell me your position. What do you do? Disagree, blah, blah, blah. If mom has witnesses, then she will present those witnesses, direct examine those witnesses, ask questions. The appeal specialist can then cross-examine those witnesses. The whole thing about cross-examination is to try to convince the judge that that evidence or that testimony should not be given so much weight, right? So, for example, if I say to, so you say that Emilio is non-self-directing. Can you tell me what your schooling is with regard to autism, for example? And they may not have never have had, they may not even be aware that much about what autism is or the degree that, in the spectrum where Emilio kind of falls into. And if I can bring that out, then the judge is going to have to question how she could say that he's non-self-directing, right? Like she doesn't have the background to determine that he's self-directing. Now, sometimes I've heard this where the appeal specialist may take away the protective supervision because the claimant can state his name, state what can happen if there was an emergency. But sometimes, especially kids are taught what to say, but would they really do? Like, would this child really call 911? Probably not. So sometimes the social workers will use the like, where do you live? And they give an address. That doesn't have anything to do with being self-directed. It's the ability to understand that with the behaviors you are about to engage in will cause you injury. It has nothing to do with knowing your name, stating what you've been taught about how you would do in case there was an emergency. But anyway, it all gets confused, right? And you just need to bring that out. County's responsibilities at the hearing, they have to summarize the position that the county has about the case, examine witnesses, cross-examine claimant's witnesses, respond to questions that the claimant or the judge may have the case file available, has the burden of proving of going forward at the hearing to support its determination, and have the authority to make binding agreements at the hearing. So that's, and the MPP, this is where you will find that information. Okay. This is about the record closes at the end of the hearing. If the judge hasn't left the record open, the judge will give instructions as to next steps, the timeline for the decision, 90 days from the end of the hearing, unless you waived it for whatever reason, then the judge will have more time. And the decision is what the judge decided. Now, the director of the California Department of Social Services can change the judge's decision. It's called an alternated decision, but the director has to do it based on the facts and the law. Okay, it's not just because the director didn't like the decision. It has to have a foundation based on law and fact. And sometimes I've seen cases where the judge decided in favor of the claimant, the alternated decision changes that judge's decision not in favor of the claimant. And then you either go to a rehearing or you go and you fought or you go to superior court and we win. So the alternated decision doesn't necessarily mean that it's the correct decision, but it's a decision that's been issued. So if it happens in the case here, Emilio's mom will receive the judge's decision and it'll say void. On top of that, the alternated decision, and that'll be the decision. They both say what your appeal rights are. Now, your next level of appeal is to go to superior court. But you could also ask for a rehearing, and it's not always granted. It doesn't always have to be granted. If you were going to go to a hearing, you should request the recording of the hearing because that's the evidence, the oral evidence that was presented, because you can use an attorney if you can find an attorney to do it. And the attorney's going to want to review the evidence to see if it's a case that he or she may want to take. If you win at the superior court level and you used an attorney, you could ask the court to grant you reasonable attorney's fees. So the rehearing, you have to do it within 30 days of receipt of the decision. You have to state on your rehearing request when you receive the decision, because they're sticklers about the 30 days, and why you're asking for a rehearing. Do you feel that the judge was biased? Do you feel that the evidence does not support the finding? That the evidence presented in this case with regard to Emilio doesn't support the finding that he doesn't require protective supervision because he's self-directing, because he doesn't require 24/7 supervision. If you're going to, you can submit new evidence, but if you're going for your rehearing at the time you request a rehearing, but you're going to have to describe the evidence, why it wasn't submitted earlier at the original hearing, why it's material, and why it would change the decision. Complying with the decision. So once the county gets the decision, it has to initiate compliance. They have 30 days to comply with the decision and submitted a compliance report with state fair hearings. You can contact state fair hearings or CDSS. I would do state fair hearings. If the county has not complied within 30 days or has not complied completely or has not complied, did something different than what the decision says. And upon notifying state fair hearings, they'll take appropriate action to make sure that the county complies. Some resources from Lisnick on how to represent yourself at the hearing, some tips. We've got some information in our IHSS publication on appeals also. So we have an intake line. So if you have any in-home supported services questions, or you get a notice of action, you can call our intake line. You can also visit our website here. So we have come to the end of the presentation. We're going to go ahead